Hello and welcome back to My Safety Hub, your go-to source for all things health and safety. My name is Steen and thank you for joining us once again for another weekly review session. Just a quick disclaimer before we get things going. Everything we say during these sessions are purely opinionated and does not constitute any type of legal advice. Now, that being said, I'm joined here today again with Ockert Fourie. Ockert, how's your week been?
Hi Dylan, yeah, it's been eventful so far. Couple of interesting things and developments happening in the world all over, and particularly with South Africa. So, yeah, it's going to be an interesting couple of months in the future.
Indeed, I've seen some speculation on the news, but we'll leave that for a different video. I think we need to wrap up what we started with in the previous two sessions. So just as a quick recap for the viewers out there, in the last two sessions, we spoke about employer and employee responsibilities, and I think we painted a fairly good picture of what we can expect from both of these parties to make sure that the workplace is safe for everyone. But there's one key element missing in this picture before we can move on to other subjects, and this is in regards to contractor management. Now, this is a very controversial section and frowned upon with some employers and self-employed persons, and as such, there's a lot of questions coming out of this, and for that reason, I think we need to explore the sections relating to self-employed persons, contractors, mandatories, and what the employers and employees can do to assist them, as well as help them out to make sure they work safe on every single workplace. So with that being said, I want to start off with section 9. So the first section, as mentioned, is section 9, the general duties of employers and self-employed persons to persons other than their employees. Now, this is a section that we spoke about in previous sessions. However, I want to delve a bit deeper into this because this relates directly back into section 12, section 11, and most importantly, section 37. So let's just have a quick recap on what this section says. Again, the text highlighted in blue is the current legislation, and the grey highlighted blocks is the proposed on the amendment bill. So, 9.1 says, every employer shall conduct in his undertaking in such a manner as to ensure, as far as reasonably practicable, that persons other than those in his employment, meaning contractors and mandatories, who may be directly affected by his activities are not thereby exposed to hazards to their health and safety. So in essence, this section here says the employer needs to make sure that persons other than those in his employ, like contractors, also have health and safety present in their working environment while working on their site. 9.2 says, every self-employed person shall conduct in his undertaking in such a manner as to ensure, as far as reasonably practicable, that he and other persons who may be directly affected by his activities are not thereby exposed to hazards to their health or safety. So this section speaks directly to the contractor or mandatories now and saying that if they conduct work on a client's premises, their activities shall not pose any hazards to the health and safety of their clients. So a very sound section, but let's have a look at the amendments they've made here. Every employer shall conduct an undertaking in such a manner to ensure that the risk posed by the identified hazards to persons other than those in the direct employment of the organization who may be directly affected by the organization's activities are not thereby exposed to hazards to their health or safety, and the risk is managed in line with the risk management plan as contemplated in section 8.2a. So here we can see the introduction of that risk management plan again, and this makes provision to the contractors and mandatories to say to them, listen, when you work on site, you cannot just work on site and say that everything is safe and the employer must believe everything you say. You now need to have a plan in place and vice versa. A risk management plan by the employer also needs to be in place for any contractors or mandatories. Section 2 says, every self-employed person shall conduct an undertaking in such a manner as to ensure that risks posed by the identified hazards. So again, this now tells us that you as the contractor, before you can go to site, we need to have a risk assessment, because how otherwise do you identify these hazards? So that's a very good addition to what we already have. To the self-employed person and any other persons who may be directly affected by the activities of the work performed on the premises are managed in line with a specific risk management plan as contemplated in section 12.1. So again, the introduction of that risk management plan comes to play here for both the self-employed person and the contractors and mandatories and the employers all at once. So one cannot get away without a risk management plan. So Ockert, what is your take on that?
Well, I think it's, with a focus on the contractors or mandatories, as the case may be, and as the topic is now for today, I think the new Section 9 just, brings it back to the foundation in saying that, yes, as an employer, you have a responsibility towards your employees and any other person who may be affected by your actions or omissions or by your activities. The part about Section 9 that I really enjoy is the fact that it does highlight those employers or self-employed persons who may or may not be contractors or suppliers or vendors for other organizations. And with that being said, how Section 9 also asks them to consider the safety for themselves as well, and then also naturally any other person as well. So you're 100% correct in saying that there has to be a risk management plan from the employer and from the contractor. Both these parties would need to have their own risk management plans. They would need to have their own risk assessments. And then also, as it then relates to Section 12, and we're going to go there now to see how that relationship is actually built. But I also enjoy the way that the new legislation is actually referencing other pieces of legislation, such as where it refers to 8.2a and 12.1, and why these decisions need to be made, excuse me, and why these risk management plans need to be put into place. Like I said, we're going to go there now. So far, yes, it's basically saying whether you're a big corporate or whether you're a small company, you're a self-employed person, you still have to comply with the Act. You still have to have a risk management plan in place. You still need to have a risk assessment in place, because the fact of the matter is your activities can harm others, it can harm yourself. So you need to take these steps and look after yourself. It's not just health and safety or the Health and Safety Act or the bill that we're discussing now. It's not only relevant to those companies with 5 or more, or 10 or more employees. You've heard those rumors. I've heard those stories as well. Irrespective of how many employees you have, this applies to you. If you're performing work and there's risk, you need to look after that risk. And it's the end of story.
I fully agree. So irrespective if you are a one-man band or mega corporation, this applies to absolutely everyone. So with that being said, let's continue further and go to section 11, which talks about listed work. Because 9 times out of 10, when an employer contracts mandatory to do work, that work is very often considered listed work, such as hot work, cold work, working at heights, etc. And this forms part and parcel of the foundation that Section 9 laid for us. And you'll see when we get to sections 12 and 37 how this becomes prevalent and why this is so important. Think of this as like an intermediary section to get us to where we want to go with section 37. So let's have a look at section 11, listed work. So the minister may, subject to the provisions of subsections 2 and 3, by notice in the Gazette, declare any work under the conditions or circumstances specified in the notice to be listed work. Listed work, essentially work that is deemed too dangerous to be conducted by the average working person. Okay. So section 2a then says, this is an addition. Before the minister declares any work to be listed work, he shall cause to be published in the Gazette a draft of his proposed notice, and in the same time invite interested persons to submit to him in writing with a specified period comments and representations in connection with the proposed notice. Okay. So we'll see this is much of the same story with the amendment, or the proposal rather. Before the minister declares any work to be listed, work he or she shall rather, after consultation with the council, cause to be published in the Gazette a draft of his or her proposed notice, and at the same time invite interested persons to submit to him or her in writing, within a specified period, comments and representations in connection with the proposed notice. So much of the same story that we are in currently with the proposed amendment bill. You know, it was written, first publication was set out, people were invited to comment on the bill, and that's much of the reason as why we've waited since 2020 for this to be promulgated. But it's good. It attracts the attention of the public and interested parties to weigh in on certain sections, which I feel is a very good thing. Okay. So further to that, we can see here that B says, a period of not less than 3 months shall elapse between the publication of the draft notice and the notice under subsection 1. The provisions of subsection 2 shall not apply if the minister is in pursuance of comments in the representations received in terms of subsection 2a, decides to publish the notice referred to in subsection 1 in amended form, and to any declaration in terms of subsection 1 in respect of which the minister is of the opinion that the public interest requires that it made without delay. So in other words, when it is a necessity to make something listed work. Then 4 has been changed. A notice under subsection 1 may at any time be amended or withdrawn by like notice. And this goes on to say, the proposal, a notice referred to in subsection 1 may at any time be amended or withdrawn by like notice. So much of the same story there. So not a lot of changes we can see here, Ockert, but I feel that the foundation of section 11 was very sound. Do you think that the changes will have a more positive effect on listed work?
Well, I like the inclusion of a council, as a framework or point of reference to discuss these matters, and how the listed work is to be applied and how it's to be controlled. It's because naturally, all of this listed work, all of these items would be supported and would need to be regulated. So we're looking at all the regulations supporting the Act, and having a council, call it a special council that is now in place and available to work with the minister in making these decisions. I think that's a good thing. What the council consists of, that's a question I would like to have answered, is who would be the representatives on this council? Would it be persons with special levels of knowledge or special levels of expertise in some of the industries, or in labor, as it may be as well? So I'm essentially just asking the question, who's on the council?
Yeah.
But from a section 9 to a section 11 move, we understand now that all employers, whether they're self-employed or others, that need to look after the employees, and they also have to look after any other person that may be affected by their actions. And this obviously relates to listed work as well, because if you're working at heights, it's listed work. Confined space entry is listed work. You've mentioned a few of them as well. The next question is, how does this then relate through to section 12, and how does section 12 speak back to section 9? Because section 9 specifically mentioned section 12, so how does the one relate to the next? And that's what we're going to discover now.
Definitely. So there was a very good reason for the inclusion of listed work, which will become prevalent in just a moment when we read through section 12, the general duties of employers regarding listed work. So again, we now understand what listed work is. We now move into what is the duties of the employers regarding this type of listed work. So let's have a look at the current statements. This says, subject to such arrangements as may be prescribed, every employer whose employees undertake listed work or are liable to be exposed to the hazards emanating from listed work shall, after consultation with the Health and Safety Committee established for that workplace, then identify the hazards and evaluate the risks associated with such constituting a hazard to the health of such employees, and the steps that need to be taken to comply with the provisions of this Act. As far as reasonably practicable, prevent the exposure of such employees to the hazards concerned, or where prevention is not reasonably practicable, minimize such exposure, and having regard to the nature of the risks associated with such work and the level of exposure of such employees to the hazards, carry out any occupational hygiene program and biological monitoring and subject such employees to medical surveillance. So in essence, what this means is, if the employer's employees undertake any type of listed work, we can see here that they make mention of some form of a risk assessment to say that the hazards need to be analyzed, the risks need to be analyzed, and precautionary measures should be taken. These precautionary measures might come into play or consider things such as hygiene surveys, such as ergonomical surveys, noise, ventilation for confined space entry, etc. So again, a very solid foundation that we have here, because here they started talking in the direction of risk assessments, risk mitigation, or hazard mitigation rather, and started talking about what control measures one can put in place. So let's have a look at what the proposed amendment says with this regard. An employer shall conduct a risk assessment. So immediately we can see they started leaning in the direction of a risk assessment here, and now they say you shall conduct a risk assessment in relation to such listed work and develop and implement a risk management plan in respect of these risks identified for work. So again, here we see a reiteration of that risk management plan in conjunction with that risk assessment. This is much more clear-cut than it was here. They were on the right track, but I think they've nailed this first statement. Secondly, a risk assessment conducted for that workplace shall be conducted by a person or persons who are competent to pronounce on all the risks associated with that work and where the risk is complex in nature. A risk assessment shall be conducted by specialists who are competent to pronounce on all the risks associated with that particular work. So they've introduced the risk assessment in conjunction with the risk management plan, and they further on went to say, when you do that risk assessment, it will be conducted by a competent person in relation to that specific set of hazards or that specific task. So you need to prove competence with this regard, which again I feel is a very, very valid point here. Then C says, the employer shall ensure that a workplace specific risk management plan is in place and is available at the workplace when requested by an inspector. Again, where employees or contractors go to site, that risk management plan needs to accompany them and be site specific, which in this regard is considered workplace specific, but in essence that means you cannot have a general risk assessment or general risk management plan and copy and paste this if you have multiple sites. It needs to be specific for each individual site, because the hazards, the risk levels, they differ from place to place. So again, a very solid entry there. Then the last one, number D, or letter D rather, an employer may not permit any listed work to be undertaken unless the control measures contained in the risk management plan are complied with. So a very, very interesting section here, and this speaks directly to our permit to work sections, right? How do you ensure that the control measures in this risk management plan are complied with? The only valid way to do that is with a permit to work system. And then section 2 here remains fairly the same. Every employer contemplated in subsection 1 shall keep the health and safety representatives designated for their workplace or sections thereof informed of the actions under subsection 1. So basically keeping the she-reps informed in their respective workplaces or sections thereof and of the results of such actions. So what did you do? What were the consequences of those actions? Provide that individual results of biological monitoring, medical surveillance, that's again speaking to the controls above, relating to the work of the employee, shall only with the written consent of such employee be made available to any persons other than the inspector, the employer, or the employee concerned. So if there's sensitive information, this pretty much just says that it will be shared only with the desired people and will not be leaked for any other persons that are not concerned with that information. So this, Ockert, is a subsequent change to what we have currently. What is your thoughts on this?
I'm rather fond of this amendment for a few reasons. First of all, for self-employed persons or contractors who may be performing listed work on site, the days of having a generic health and safety file, the Bucky file as they call it, on hand
Yeah.
with a risk assessment in it for every single client, for every
Yeah.
site out there, those days are now gone. Now it's a very specific risk assessment that needs to be developed, and with it a risk management plan that needs to be developed and implemented by those self-employed persons or by the employer if they perform the listed work themselves. And then obviously this has to be conducted by a competent person. Now,
Yeah.
for me, the interesting question here is what is that competency defined as? According to what level of knowledge or experience, what degree do I need to be able to develop this risk assessment or to conduct this risk assessment and to be able to pronounce on these risks as being at a level of danger of X, Y, or Z? That I feel is something that would still need to be discussed. And then further than that, if we look at the risk management plan and the implementation or the start of work, you've mentioned the permit to work system as well. I would think that if you have your permit to work system, there would have to be someone that manages it, someone that monitors that the permit is being executed properly, and there's a proper handover procedure to be conducted as well from employer to contractor and contractor to employer, therefore to make sure that the level of risk was managed properly. And again, this has to be managed by a competent person.
Yes.
And again, that's just another question that I have as how do you define that competency? Because my definition of competency is knowledge plus skill plus attitude. And then you're competent to do whatever you are focused on. But that's probably not good enough for the law. And I would maybe suggest or ask that they bring in a definition and maybe even define competency for every item of listed work, so that whoever these health and safety professionals are that are conducting the risk assessments and putting together the risk management plans, so that they know what the standard is in terms of competency, what level of experience or knowledge they would need to have or attain to be able to conduct or complete this risk assessment and its management plan as well.
Definitely, I agree. So still a few questions that remain unanswered here, but I do believe that this is a very welcome addition to what we've already have in place here. And keeping in mind that this is the employer responsibilities regarding listed work, but we must know that these employer responsibilities are not only for your employees only. These responsibilities go for absolutely every person, whether that be an employee, contractor, mandatory, self-employed person that is on your workplace or site for that matter. This becomes real then. Okay. So tying all of this together now, we move on to section 37. And this is specifically related to everything that we spoke about today. And this is in regards to our contractors and mandatories and what we actually need to do in situations where we contract out our work. Okay, so let's just get there. That's quite a few sections onwards. We're skipping the gun quite a bit, but it will make sense in just a moment. So, section 37. So, section 37 says, acts or omissions by employees or mandatories. Whenever an employee does or omits to do any act which should be an offence in terms of the act for the employer of such employee or user to do or omit to do, then, unless it is provided that in doing or omitting to do that act, the employee was acting without the convenience or permissions of the employer or such user, it was not under any condition or under any circumstance with the scope that the authority of the employee to do or omit to do an act, whether lawful or unlawful, of the character of the act or omission charged. And here we can see, here comes the amendment. So let's read the current one. All reasonable steps were taken by the employer or any such user to prevent any act or omission of the kind in question. The employer or any such user himself shall be presumed to have done or omitted to do that act, and shall be liable to be convicted and sentenced in respect thereof. And the fact that he issued instruction forbidding act or omission of the kind in question shall not in itself be accepted as sufficient proof that he took all reasonable steps to prevent the act or omission. Now, we'll see here that the amendment speaks very much the same language here, but you'll see there's a few small tweaks. So, all reasonable steps were taken by the employer or any such user to prevent any act or omission of the kind in question. The employer or any such user shall be presumed to have done or omitted to do that act, and shall be liable to be convicted and sentenced in respect thereof. And the fact that he or she issued instruction forbidding act or omission of the kind in question shall not in itself be accepted as sufficient proof that he or she took all reasonable steps to prevent the act or omission. So in essence, what this says is the employer's word against the mandatory's word shall not stand in court. There needs to be written instruction, written proof. That's where the permit to work systems comes into play, the risk management systems and the risk assessments with this regard. We can see further on to this, number 2 stays the same. The provisions of subsection 1 shall mutatis mutandis, or as it stands, apply in the case of a mandatory of any employer or user, except if the parties have agreed in writing to the arrangements and procedures between them to ensure compliance by the mandatory with the provision of this act. Now, this is where section 37.2 or the contractor agreement derives from. So basically what this says, the employer may contract a contractor to perform work on his site, but he may not move the responsibility or accountability over to the mandatory without having his ducks in a row. So as we now saw in section 9, 11, 8 and so forth, the employer needs to develop that management plan, health and safety management plan and risk assessment, which includes items that may be performed by contractors, visitors, members of the public. Now, before we move on, Ockert, I know you have very strong insights on these sections. So before we continue with 37 and the rest, or the rest of 37, what is your take on this?
To start with, let's just go back to section 9. Right. So section 9 makes it clear that you have a duty to care for everybody else and not only just for yourself and not only for your employees. Anybody that can be affected should be thought of, and your risk assessment has to consider that and consider the public, consider your contractors. That whole picture has to be put together. We then defined what listed work is, and we understand that it's not the type of work that just anybody would have to do. You would have to go for specialized training, and we now know that a special risk assessment would need to be conducted for the listed work to be carried out, and that a permit would need to be issued for that work to be done according to what section 12 has said. Now, when we get to section 37, the picture is drawn and it says that we understand that both the self-employed person or contractor and the client, who is also an employer, both parties are employers, have a responsibility under section 9. Both parties have a responsibility under section 12, which says, do a risk assessment, build a risk management plan, issue permits for listed work. Now we get to section 37, and it says that if someone does something wrong, whether it's now an employee or contractor, and that person didn't have permission, they were acting outside the scope of their authority, so whatever the agreement may be, and even if we consider those and all other reasonable steps that may have been taken to stop the incident from happening, it's made very clear that saying, no, you're not allowed to do this, is not enough to be sufficient in saying that those are all reasonable steps. You need to provide evidence to show that you have done more to prohibit or control the risk or negate the situation or remove the unsafe act. And if you didn't, you as the employer would be presumed as if you have carried out this act yourself. And that's called vicarious liability. So you go where your employees go. And if you have a contractor coming onto your premises and you don't come to an agreement, 37.2, to say how both parties will work together to manage risk, to implement a risk management plan, both of them would have their own risk assessments, both of them would have their own risk management plan. Section 9 made it very clear, Section 12 made it very clear that it's not only the client's responsibility to have a risk assessment and a risk management plan. Currently, as it stands, I've had conversations with employers that would tell me that the contractors would invoice them to build a safety file, to build a site file. So the client now has to pay for another employer's health and safety file. The client now has to pay for another employer's risk assessment, where that employer, who is the contractor, under the law, is responsible for complying with the Occupational Health and Safety Act, the current legislation, as well as the upcoming new legislation, which we are discussing now. For me, that's absolutely ludicrous. Why don't you just pay their taxes for them as well?
Sure.
I mean, it makes no sense whatsoever for any client to have to pay for another business's health and safety compliance. And in doing so, to create the idea, the illusion actually of compliance, because I can tell you there's no buy-in towards risk assessment, risk management, risk control, and looking after the well-being of the people that could be affected by your actions or omissions according to Section 9.
Yeah, and but unfortunately, Ockert, that is all the time that we have for today. Again, we've painted a much larger picture now with regards to employers, employees, the contractor management side of things as well. In next week's video, we'll continue through the amendments or the proposed amendments for Section 37 and a few other sections that form part and parcel of this. But another very fruitful session, Ockert. Thank you very much. And as always, stay safe, stay inspired. And until next time, take care.
Cheers.